So how does Article 4(1), which deals with the concept of residence and the concept of residential status under the Income Tax Act of India, interplay? I mean, can I say that if a person is a resident under the Income Tax Act, so far as domestic laws are concerned in India, he will be entitled to the benefit of the India or any other treaty that it is there? Or is it that you need to have satisfied some condition for Article 4(1) before you can claim the benefit of the treaty? Now, residential status under the treaty does not mean residential status under the IT Act and vice versa. What this means is, if you become a resident under Article 4(1), but you are not a resident under the IT Act, right? These are two different situations. Just because you are a right in one does not mean it is right automatically in the other, right? The second thing is that even if a person is resident under the IT Act, he should satisfy one of the criteria under Article 4(1). If he does not, then he cannot claim the benefit of the treaty. And the third is that the taxation in India should be comprehensive and not restricted to only income sourced from India. This we saw in one of the previous slides where we said that the term resident does not include a person who's liable to tax in a contracting state in respect of only the income which is sourced from that state. What this means is that the taxation in India has to be a comprehensive one. If you're only liable to tax for India sourced income, right, then even though that taxation might be because of place of management, place of incorporation, or any other criteria which is discussed in Article 4(1), you will not be treated as a resident.